Madeira Beach Special Exception Use Special Magistrate Hearing. My name is Bart Valdez, and I'm the appointed Special Magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 18 years. I've been appointed to this position in accordance and with the authority set forth under Florida law and the City of Madeira Beach Code of Ordinances. It is my role to fairly and objectively review the matters presented today in these various requests. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. At this time, I have read and reviewed the application with all attachments, any written submissions by anyone having an interest, any timely submitted written objections, and the written materials provided by the city staff. In all cases, the hearing will be conducted in the following order. First, we will confirm that public notice has been proper. Second, the city will present its case and staff report, and the applicant may ask questions of the city's representative. Third, the applicant will present his or her case supported by witnesses and evidence, and the city may cross-examine each witness. Fourth, public comment will be solicited or received from parties directly affected by the variance. Individuals testifying do not have the right to cross-examine the parties. All public comment shall be limited to 3 minutes per person unless waived by the city. Public participation will then be closed. I will deliberate and then make a decision to grant or deny each request in the application. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After my decision today, I will issue an order. The order will be reduced to writing, and you will be provided with a copy by mail. Therefore, for the applicant, please make sure that we have your current address. Additionally, you are advised that I do not have the authority to grant you a building permit. You must still obtain a building permit for any work you intend to do on your property. If you wish to present any information to me, it is necessary that you swear or affirm that you will tell the truth. Therefore, in just a few minutes, the city clerk will administer the oath and swear in any witnesses. If you expect to talk to me today during the hearing on your special exception, then you need to rise and be sworn. This includes any members of the public who are directly affected by the variance or special exception and may wish to provide public comment. We're going to have the code enforcement hearing immediately following this hearing, so if you're here on a code enforcement matter, there's one item on the agenda that we're going to take up first on the special magistrate special exception use agenda. So we'll do the special exception variance use first and then move to code enforcement. So for anyone that is here in regard to application 2019.01, the property owner is Admasol Group, LLC, Darko and Zarko Gligorevic, and the property address is 15392 2nd Street East. If there's anyone who would like to present anything today, whether public comment or any other kind of comment to me in regard to that special exception use application, I need you to rise at this time or raise your right hand and be sworn in by the city clerk.
And you guys have to stand because you represent that property. Okay, do you swear to tell the truth? Raise your right hand. Do you swear to tell the truth, the whole truth, nothing but the truth? I do. Thank you. You may be seated.
All right, Mr. Brooks, I have the first and only item on the agenda is application 2019.01. Has notice been properly provided?
Yes, sir.
All right, Mr. Brooks, are you ready to proceed?
Staff will make the initial presentation, followed by the applicant, followed by any public comment.
Sounds good.
All right. I'll be going through the 10 requirements for special exception along with staff's analysis. Requirement 1, that the use is a permanent special use. Under section 110-319, number 8, single family or duplex. A duplex is a permitted special use in the C3 zone. Requirement 2, that the use is so designed, located, and proposed to be operated that the public health, safety, welfare, and convenience will be protected. The use is cited as a special exception use in the C3 retail commercial division. The use poses no threat to health, safety, or convenience of the community and contributes in a positive manner to the landscape and open space in the neighborhood, thus potentially enhancing the public welfare and property value. Requirement number 3, that the use will not cause substantial injury to the value of other properties in the neighborhood where it is located. The proposed structure will comply with the standard setbacks for the C3 retail commercial zoning and will not cause substantial injury to the value of the property in the neighborhood. Requirement 4, that the use will be compatible with adjoining development and the proposed character of the district where it is located. I would ask you to look at page 18 of this packet that shows the adjoining properties and their uses. Within the block, there is an apartment complex, 2 lots designated for duplex, triplex, fourplex, 1 single-family resident, 1 vacant commercial lot, and 2 professional office buildings. If this lot is used as a duplex, the use is compatible with the adjoining development. Requirement number 5, that adequate landscaping and screening is provided as required in the land development regulations or otherwise required. The green space and landscaping will follow the C3 retail commercial zoning regulations for duplexes and will be adequate. All new single-family duplexes and triplex residential development shall include a minimum of 25% landscaped area, which will include native or non-native introduced trees and vegetation, as per section 106-33 of the code. Number 6, the adequate off-street parking and loading is provided and ingress and egress is so designed as to cause minimum interference with traffic on abutting streets. The proposed duplex will conform to the parking standards in section 110-971. Number of spaces is noted in the table of required parking spaces. Requirement 7, that the use conforms to all applicable regulations governing the district where located, except as many otherwise be allowed for planning unit developments. The use conforms to all applicable regulations governing the district where located. Requirement 8, if a variance is also desired and or required, a separate application shall be submitted concurrently with the special exception application. An administrative waiver was granted to allow for the density of 2 residential units as per section 86-29 of the code. The comprehensive plan allows 2.5 residential units for a lot with an area of 5,936 square feet. Requirement 9, special exception use will not grant to the land more privilege than the best use available in the zone, where that special exception would be a principal permitted use. The duplex will not grant the land more privilege than the best use available in the zone. And lastly, the requirement 10, no application for special exception use shall be considered by the special magistrate until the applicant has paid in full any outstanding charges, fees, interest, fines, or penalties owed to the city by the applicant or property or owner or possessor of the property under any section of the code. All fees have been paid for the special exception review process and the applicant has no outstanding charges. The staff recommends the approval based on the applicant meeting all the criteria for the special exception.
Could you clarify for us on page 18, which is the subject lot? That was the map of the surrounding uses?
Yes. It's this red lot.
Okay, if you look at the legend, it says subject property, and it's the red lot between what 2 uses?
An apartment and a single family.
Okay. And then the administrative waiver, could you describe that one more time? That deals with the 3,000 square feet minimum for each unit?
Yes. So the subject property is, I believe, shy of 64 square feet. So administratively, we can waive up to 15% of that. So since they're so small, we were able to do that administratively.
Is there anything else you'd like to add to the staff presentation?
That is all. That's all.
Ms. Rowan, I want to make sure I've got this right. The special exception I'm being asked to grant is to allow just simply a duplex within that C3 zone property. Is that right?
Yes, sir.
You don't need any kind of special exception. There's no variance requested on the square footage because you've already administratively dealt with that.
Correct.
All right. And I just want to make sure I'm going to go ahead and accept into evidence pages 1 through 25 of the special magistrate special exception hearing for case number 2019-01. Is there anything else that you'd like me to consider as part of your testimony today?
No.
And I take it, I see on page 24 and 25 that notice was posted on the property. Has notice been properly provided?
Yes, it has been.
Have there been any objections, written objections received by the city?
Not that we've received.
All right, is the owner or somebody on behalf of the owner here? All right, sir, come on forward. All right, this is the part of the hearing, if you want to. You are not required to, but if you want to ask any questions of Ms. Rowan based upon what she has set forth here today, either in response to Mr. Brooks' questions or in response to my questions, you can ask her questions. In a few minutes, I'm going to give you an opportunity to address me with anything you want, but right now is your opportunity to ask her any questions. Do you have any questions for her?
No, sir.
All right, thank you, sir. You may be seated. Ms. Brooks, is there anything else that the city would like to present before I ask the applicant to come forward?
No, Your Honor.
All right. Sir, come on back up. Should have just had you stand there at the podium. Sir, what is your name?
Zarko, Z-A-R-K-O is my first name. My last name is Gligorevic. It's G-L-I-G-O-R-E-V-I-C.
All right, sir. This is your opportunity. If there's anything else you'd like to tell me in support of this application, I think I understand it. The city is recommending approval of it. But is there anything you'd like to share with me, any witnesses you'd like to call, any documents you'd like to give me, or anything like that?
No, sir, I think she explained it in a very good detail, so I'm satisfied with it.
All right, thank you. And I'll give you, if there's public comment and you want to come back up later and tell me something else, that's fine. But for now, you can go back and sit down. All right, at this point in the proceeding, we will accept any sort of public comment. Any members of the public that would like to come forward and speak on this application? Sir, please give me your full name.
Steve Kochick, 15301 2nd Street East, Madeira Beach.
All right,
Trustee
hold
for
on,
the
hold on,
William
hold on.
Demetrian Trust.
All right, hold on. Give me your last name again and spell it for me.
Kochick, K-O-C-H-I-C-K.
And you said your address is what?
15301 2nd Street East, Madeira Beach.
Okay, and you said you're here on behalf of which entity or which person?
I'm the trustee for the William Demetrian, D-M-Y-T-T-R-Y-A-N Trust, the owner of the Mark I Apartments.
All right, so let me just make sure I've got this right. You represent the owner of the apartments that are at the end of the street, is that correct?
Yes, across from the whole, my building is right there. You see
Okay.
at the end of the canal?
Okay,
That's it.
all right. All right, sir, what would you like to tell me?
Yes, I have no problem with what's coming up in there. I think either side, they look like single-family homes. I know you said an apartment and a single-family house is on each side of it when it was stated. But the reason why I'm here is just from the drawing, it's difficult if that's what the building is actually going to look like. What I'd like to impress upon the owner and the architect is this is the entranceway to one of the residential neighborhoods of Madeira Beach. And the buildings that are on the corner are back from the 60s or earlier. And what now has been going around Madeira Beach is trying to establish a criteria for building that accentuates the neighborhood, makes the neighborhood gives it a vision of itself, whether it's something that's a little more Floridian, whether it's Key West type, or just general Floridian. I would hope that in the design and maybe thinking that without a lot of expense, the building could be made as a standard that can be set for the other builders to come in the future to copy their designs and say, this is something that the neighborhood wants. This is something that the neighborhood is hoping that to be achieved to enhance the neighborhood and bring the quality of life even higher to Madeira Beach than we already have. It's been spoken about in our master plan from 2000 that this is what new construction should be done. It should be looking at the overall look at the community and fit in and try to set a standard that other builders can follow. So we have a continuity and we have something that everyone is proud of, not only the builder, but the other residents, to where there's not the squabbling that sometimes we have as to what new construction is looking like. And I just would hope that the architect inexpensively could do little things which will bring that concept into a reality. Thank you.
Thank you, sir, for your comment, and I understand exactly what you're saying. All right, are there any other members of the public that would like to comment on this application? Okay, seeing none, we'll go ahead and close the public comment portion of the proceeding. Is there anything else from the city?
Not at this time.
All right. Based upon the staff report, which was excellently done, as well as the fact that it meets all of the standards required, and based upon the staff's recommendation, I too am going to go ahead and approve the special exception sought in the application. So I will go ahead and reduce that to an order and then send the order out to the city and everyone. Are there any other matters that need to come before me in regard to the variance or special exception use hearing?
No, sir.
All right. We will go ahead and close the variance and special exception use agenda. Gentlemen, you're welcome to stick around for code enforcement if you want. I don't know if you have any business there, or you can leave for that. All right, is everybody from the city ready to move on into the code enforcement section of the hearing?
Yes, sir.
Excellent. Welcome to the City of Madeira Beach Code Enforcement Hearing. Again, my name is Bart Valdez, and I'm the appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 18 years. I've been appointed to this position in accordance with the authority set forth in Chapter 162 Florida statutes. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. Every effort will be made to hear all persons having relevant evidence, argument, or comments to offer related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in by the city clerk. In all cases, since the city has the burden of proof, the city will present its case first. The respondent then will be given an opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and you will be provided with a copy by mail. Therefore, please make sure that we have your current address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and to provide you a reasonable time to correct the violation by whatever means is available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline. If you wish to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, at this time, the city clerk will swear in any witnesses. Please rise and raise your right hand.
Do you swear to tell the truth, the whole truth, nothing but the truth?
I do.
Thank you.
All right, the first case that I have on the agenda is case number 662. The respondent or property owner is 13435 Gulf Boulevard LLC, and I note the property location to be 13437 Gulf Boulevard in Madeira Beach. Is the city ready to proceed on this matter?
Yes, Your Honor.
All right, go ahead and call your first witness.
The City of Madeira Beach calls Code Enforcement Officer Holden Pinkard.
So the property in question was found to have violated Section 86-52. New electrical work was done in the rear of the property to connect a trailer. At the time when we found the violation, it was operating as a business, but I believe that business has since closed. So it's unoccupied right now, but the violation still exists.
Is this a food truck trailer?
Yes.
Okay.
But again, I believe the business is closed now.
Is it still plugged in?
No.
Okay. And could you please describe how we gave notice and who we gave notice to?
Regular mail and certified mail was sent to the property owner via the Pinellas County Property Appraiser's Office.
And the trailer still remains on the property?
No, I don't believe so. The main concern was the electrical itself that was brought out to power the trailer.
Does the electrical itself still remain on the property?
Yes.
Okay. And what action needs to be taken to bring the property into compliance?
A licensed electrician would have to apply for a permit, and I do believe we did receive an application for that work. I believe that property, they're intending on renovating both of those properties. They're right next to each other into an event space, and I think this is something they want to clear up quickly. But I do know we received a building permit application for this after-the-fact work as of today.
And is the after-the-fact work shown as depicted on page 16 in the photograph?
Yes, it's a little hard to see, but you can see where they notched out where it says food truck on the panel.
Okay. And then is it also shown on the outside of the building on page 15?
Yes.
Okay. And so that would either have to get an after-the-fact permit or be removed, correct?
Correct.
How long is reasonable amount of time to receive an after-the-fact permit or remove it? Let me first ask you, is it operational now? Are those fuses on the on position, or are they off? Or do we know?
I'm not sure. I would ask, I'd say maybe 2 weeks at the very most.
Okay. Is there a public health, safety, life issue here?
I don't believe so because it's unoccupied, but that doesn't necessarily mean it's not a safety issue.
Is the plug available for anyone to plug into?
Yes.
And is the owner of the property present? Is it an owner-occupied premises, or is it a vacant premises? Or?
It's a commercial building right now that has been a restaurant in the past, but I believe it is not operating right now as a business. It's unoccupied.
So there's no one there to supervise the electric outlets at the building or the shed where it's coming from?
No.
Okay. Is there anything else that you would like to add with regard to this particular violation?
Not at this time, no.
Does Your Honor have any questions regarding this code enforcement violation?
Just a couple real quick. I think I understand that the nature of the violation is not only did they do some work on the inside with the panel, but they also ran something, some kind of conduit and then a receptacle along the outside of the building. Is that correct?
Correct.
All right, I'm going to go ahead and accept into the record as exhibit number 1, pages 1 through 20 of the exhibit packet. Has proper notice been provided to the landowner or the violator?
Yes.
Have you received any calls or any communications from the owner or respondent?
I have. Today I spoke with the property owner. Like I said, they're intending on doing some major renovations to that building and a building right next door into an event space. And I believe they're going to clear this up rather quickly. We did receive an application for that work that has been done today. We haven't issued the building permit, but we've received the application.
All right, the action requested I see is either the property owner and or licensed contractor need to apply for an after-the-fact building permit to keep in code compliance. Is there anything else? I mean, my concern is the applicant going to come in here and say, well, we thought we complied because we applied for the permit?
That's my mistake. I guess it would be obtain is a better word instead of apply.
Got it. Why don't we do this? I mean, they definitely have filed the application
Yes.
already? All right. I'm going to go ahead and then find that since that was a corrective action, I'll find that there's no violation today just based upon that corrective action. However, if they don't obtain that permit, it's without prejudice. You can always come back in, because I certainly understand the position here that this creates some sort of risk. I'm just concerned the violator would come in there and say, I cured. And so, based upon that specific notice, I'll go ahead and find there's no violation at this time. But again, please continue to monitor this situation. This is not saying that if they don't obtain it, that there can never be a violation in the future. All right, let's move on to the second case, which is case number 616. The respondent property owner is Victoria Cardona. The property location is 15350 Gulf Boulevard, Madeira Beach. Is the city ready to proceed on this matter?
Yes, Your Honor.
All right, go ahead and call your first witness.
First witness, we call Holden Pinkert, Building Code Compliance Officer of the City of Madeira Beach.
So the property in question was found to have violated Section 14-69 as it relates to maintenance, and Section 1470 as it relates to maintenance. The pictures on page 27, you can see the balcony is in a state of disrepair, and the page 28, the sliding glass door is shattered, the glass itself. 29, page 29, you can see the visible mold, and that's throughout the property. Most of the soffit is covered in mold. The page 30, it's it's a little difficult to see, but the ceiling in the garage has actually collapsed partially, and that is, I believe, all the violations that we're seeing. The owner, I believe, is vision impaired, so I'm not sure if she's aware of the condition of the property now, but I have been in contact with her. And this, I just want to add that this violation has existed since middle of November of 2018.
And were you able to contact the alleged violator today?
I haven't personally talked with her today. She did send me an email asking me for an extension of time. I wasn't able to return her email yet, but everything that I've sent to her via email, I emailed her all the notices And I've visited the property with our Pinellas County deputies and explained to her the situation.
By email?
In person.
Okay. And did the property owner understand the nature of the violation?
Yes, there's emails in here, I believe, from page,
Looks like starting on page 46, I see a
Right.
series of emails.
and I've tried to explain it the best I could and what needed to be done. And we had an original deadline sometime in January, February, and I was trying to work with her as much as possible, but I think it's beyond the reasonable time given.
What would be a reasonable time, in your opinion, in order to remedy these violations? And how would you remedy them and bring the property into compliance?
I believe the corrective action is spelled out on page 46. But as far as time,
Would building permits be required for these, the wall and ceiling repair and the exterior repairs?
yes, I believe so. It depends on the severity of the damage.
How long would be a reasonable time to prepare and submit a building permit application for the repairs?
I think to get all the violations corrected, I think, in my opinion, I would say 30 days as well is well enough time to correct all the noted violations.
Okay. And do the photographs on page 27 through 30, and then also 33 through 36, and 41 through 45 accurately depict the current conditions at the property?
Yes.
Is there any life, safety, or health issue with regard to these violations?
Yes, and that was our primary concern, is the interior as well. We don't know how much damage is in the garage and how far that goes up or anything along those lines.
Due to the property owner's visual impairness, her blindness, was she able to understand, she can't see them, but is she aware of the potential health threats of these violations?
Yes.
Okay. And this would be placing her in danger, having these violations continue?
Yes.
Your Honor, we are concerned with the safety of the owner and who is the occupant, and the fact that she is visually impaired and blind, and it's difficult for her to be wary of these things. We would ask that we have an order that gives her a reasonable time to bring the property into compliance by obtaining building permits and completing the repairs.
All right, just want to make sure I understand it. Mr. Pinkert, are there are two violations under 14-69, is that correct? One of them is the situation in the garage needs to be, the ceiling needs to be repaired or replaced in the garage. And then there's a second violation that relates to the balconies and the stairwell, is that correct?
Correct.
Then there's a third violation on the property, which is 14-70, and that violation is the sliding glass door being shattered, correct?
Correct.
So the corrective action would be to replace that sliding glass door. Is that correct?
Correct.
So if I understand the city's position then is that the corrective action, is it 30 days to apply for a building permit or 30 days to provide for a building permit and correct all, take all this corrective action?
We think that she could complete the entire corrective action and do the renovations or repairs all within the 30 days, and this is for her own safety. Otherwise, we would give more time. We've been trying to get these repaired for her own safety. So,
What is the proposed daily fine if she fails to bring the property into compliance.
Our primary concern is her own safety, but in order to encourage her to make these repairs and provide an incentive, we would ask for a daily penalty. Holden, what penalty would you impose if it's not completed within 30 days?
Say 250. 250.
And would that be
250?
$250 per day per violation?
Yes.
All right, also, I'll go ahead and accept into the record as exhibit number 1, pages 21 through 53 of the code enforcement hearing packet for case number 616. In regard to notice, in addition to the testimony of Mr. Pinkard, I do note that on page 47 of the packet, the respondent went ahead and acknowledged that she had notice of the hearing, but said that she can't take time off of work, but clearly proper notice has been provided and the respondent has actual notice of the violation. That being said, is there anyone here in the public, is there anybody on behalf of the respondent that would like to come forward and provide any evidence or testimony or cross-examine the city's witnesses? All right, seeing no one here on behalf of the respondent, is there any member of the public that would like to provide comment in regard to this code enforcement hearing? Okay, seeing none, I'll go ahead and close the public comment portion of the hearing. Mr. Brooks, anything else city would like to tell me about in this case?
Holden, is there anything else?
No, not at this time.
All right, I'm going to go ahead and find that the property is in violation of 14-69. There's 2 violations that relate to that particular code provision, the balcony and the stairs, as well as the garage ceiling. Additionally, there's a violation of 14-70 relating to the sliding glass door. We will give the respondent 30 days from today's date to correct that. Actually, 30 days from entry of the written order. I should be able to get to it in the next couple of days. It'll be 30 days from the entry of my written order to comply. And if not, there will be a $250 per day fine per violation, so $750 total. Anything else on that particular case, Mr. Brooks?
No, Your Honor.
Excellent. Let's go to the last item on the agenda today. It is case number 627. The respondent or property owner is DAG Brothers, Inc. The property location is 194 Boardwalk Place, Madeira Beach. Is the city ready to proceed?
Yes, Your Honor.
All right, go ahead and call your first witness.
Our first witness is Holden Pinkard, Building Code Compliance Officer of the City of Madeira Beach. Holden, could you please describe this violation?
Sure. The property in question is found to be in violation of Section 86-52, building permits when required. There have been awnings have been installed on the property on the dock, as you can see in page 61.
Does page 60 show the prior conditions before the awnings were installed on page 61?
Yes, and it looks like they previously existed in a different location on that page, on page 60, towards the back there, where I'm assuming that was some kind of checkout or check-in type of...
The far end of the pier?
Right.
On page 60.
Correct.
Those awnings have been removed?
I don't believe they've been removed. I think they were relocated to page 61's location.
Okay. And are there any awnings in the location shown on page 60 in that location?
No.
Okay. And could you please describe the notice and the service of the notice of violation?
Notice was given regular mail and certified mail. I do not believe that we received a signed receipt. I believe it was undeliverable.
That was to a post office box in Madeira Beach?
Correct.
Okay. And have you heard from the property owner?
No.
And has any application for the awnings been received?
No, and that is another thing that I discussed with Ms. Rowan. We don't know if it would be able to be permitted in the first place. I don't know if we allow structures on our docks. So it may be possible to permit it, but it also may have to just be removed altogether.
Okay. And that would be reviewed if an after-the-fact building permit were submitted?
Right,
Otherwise, to remedy the violation, the awnings could be removed,
right,
and the upright pilings could remain. It's just removing the horizontal awnings.
correct.
And is there a life safety concern with this violation?
To some degree, if strong winds, we don't know how it's fastened, so it could be flying debris.
Okay. And then are we approaching hurricane season?
Yes.
And how long is a reasonable time to remove these awnings or apply for an after-the-fact permit?
I would ask for 30 days at most.
And then do you recommend a daily penalty if they are not removed or after the fact permit is not applied for?
The 250 a day until it's complied.
And is 30 days a sufficient amount of time to get the after the fact permit submitted and either approved or denied, and have the awnings removed if denied?
Yes.
No further questions from us, Your Honor.
Give me that daily penalty again, or daily fine.
250.
All right.
Oh, could you describe what the photograph on page 71 is?
71 is the posting of the property.
And is that the front of the property has a business there?
Right.
And what is the name of that business?
That is a good question because I think there's 2 levels there. I think it's the Hut and Scully's, possibly. I'm not 100% sure which restaurants are there.
Are those restaurants affiliated with this dock, or is this dock for a different business? Or do we know?
I have no idea.
Okay.
It looks like the sign on page 64 might be, if that says Jack's, if that yellow sign says Jack's, like maybe parasail or jet ski rental.
Okay.
But the property replaced, they pulled a permit to replace all the deck boards, and the job site and project address is the same address as this violation. And those awnings were installed in the same location where the deck work was. So that's how I associated that property with this dock.
And how do we know that Dag Brothers are they the owner or are they the contractor? Do we know?
They're the owner. I have a copy here of the building permit that was previously issued, permit number 2273.
Is that part of our packet?
No, it's not. That's my mistake.
We'd like to submit that at this time, Your Honor.
All right, I'll go ahead and admit into evidence as exhibit number 1, the packet for code enforcement hearing, case number 627, which is page numbers 54 through 71. And I'll also accept in, is this a copy I can attach into the record?
Yes.
Please.
I'll put in as exhibit number 2, the previous building permit.
That reflects that the owner is Dag Brothers and that the contractor for that dock replacement was Spieler.
Got it. All right, let me just ask a couple questions, and then I will allow the respondent to ask questions of Mr. Pinkard. Mr. Pinkard, I just want to make sure I understand the nature of the issue here.
Tell them which page to turn to there.
Go ahead.
On the one that we just submitted?
Yes.
So on the 8th page of the,
Hold it up high so we can see.
yeah, it's got the highlighted yellow section.
Okay,
That's the area that is pictured, and you can see this permit that was approved by the county that has been completed was to do the deck boards and the stringers only, so that was removed and replaced, and the awnings were, I'm assuming, obviously now, were relocated. And that's how I associated this dock with this property.
okay, I think I understand the nature of the violation here, and I understand notice has been provided. I may have some more questions in a minute, but first, is there anybody here on behalf of the respondent or property owner? Sir, what is your name?
Good afternoon, Jack Bodziak. I'm an architect, and I represent the D'Agostino brothers in their holdings there.
Hold on, Jack, spell your last name for me again.
B-O-D, Z as in zebra, I-A-K.
All right, now, Mr. Bodziak, I'm going to give you an opportunity to give a full presentation to me in just a couple minutes. Right now, do you have any questions you want to ask Mr. Pinkert in the way of cross-examination or anything like that?
Actually, I don't. I think he clarified the fact that this was a relocation. There's some confusion as to who the owner is and who had the work done and all that, and that's what I want to straighten out.
All right, I'm going to give you that full opportunity, but are there any questions you'd like to ask of Mr. Pinkert at this time?
No, he and I have discussed this a little bit now today, and I think I have a pretty clear picture now of what happened.
All right, don't leave the podium, stay right there. Are there any other witnesses that the city would like to call, Mr. Brooks?
Not at this time, Your Honor.
All right, go ahead, sir. Tell me now, it's your opportunity to
Yeah,
present
sure.
the full case on behalf.
I think I can see where this got confusing to Holden, because the notice was sent out on the 15th of this month, so when it arrived at D'Agostino's, they were kind of surprised. They called me when they got word on, I think it was Wednesday or Thursday, that they had received the notice of this, and here's part of the reason that there was a lot of confusion. I just found a lot of this out since Holden and I spoke earlier. The property's on lease and has been on a lease for some time to the people that have the jet ski operation there. They are the ones that had the decking all redone on the property. They relocated the awnings, and so it was a relocation of existing awnings when they did that. Now, whether they should have or they should have put that. To me, that's a minor thing, and that it could have been mentioned on the permit. It wasn't new construction; it was a relocation. The notice going out on the 15th, I couldn't reach Frank, the principal, in it because he was in transit. He just called me and said, "What the heck is this?" The addresses are a little confused. Actually, the 194 I found it. I think it's the restaurant downstairs. It's not the one. It's not the address for the docks. The lessor, they contracted with Spieler to do the work. The D'Agostino brothers, aside from knowing that it was done, they had nothing else to do with the application. They said, "Yeah, fine. If you want to redo the docks, redo them." So all this just came down. It was mailed. The one that I got was mailed on the 15th of this month. Pretty hard to kind of get everybody together and figure out what's going on. Having said that, though, and the difference in the addresses, some confusion on that, the notice going out late, 30 days should be fine for us to, I'd rather research this a little further, but we would like to probably relocate the awnings and put in an application, since it is a relocation and not a new addition to it. I at first, when I spoke to Holden at first, one of the pictures that was involved was a picture of the other dock. So when I went out there, I looked at the wrong dock first. And then when I got here today, we went over it, and I realized that there was some confusion on the addresses, on the ownership, and on the work that was done. But I did understand it after Holden explained it to me specifically what he was talking about. I think 45 days, 30 days, I'd like to say 30 days, that we can get an application in. Holden, if that's correct, I would put an application in to relocate the awnings, because the docks were done properly. They did have a permit with Spieler Brothers. I think with the shortness of notice on this, I'd like to first put an application in to relocate those. And then if it's approved, we'd come back with that having been accomplished within 30 days. I could get that in pretty quickly. If it's denied, then, I'd like 30 days from whenever Frank or the building department review it to either remove them or, come back before the magistrate. But I won't bore you with all this, but it was just very confusing because there are two different addresses. One of them doesn't apply. The other one, the address on there, the one address on there you'll notice is Treasure Island. That's another hotel that they own that somehow was on the mailing list for one of the other partners. So
The good news is it made it to you and you're here, so.
they got me, yeah, and usually that's what happens anyway.
Anything else you want to tell me, sir?
No, I think it's a pretty clearly there was some confusion involved in this thing, not just the fact that it was redone with a permit, the docks were, and the awnings were a relocation. That I will put an application in for first and see if the city accepts it. And I'd like, if they deny it, if we get a written denial, given the short time since the letter was mailed to us, for example, the placard was posted next to one of the restaurants, so we right away thought that it would, because it didn't specifically say what it was and what I got. It just quoted the section of the code, which is pretty broad. So I'm thinking that maybe they did something in the restaurant when I first got the call last Thursday or Wednesday. So anyway, yeah, if we would put in right away for a permit, and then according to what the building department's reaction was, we'd like 30 days to either correct the action or
Sure, I understand that position. I'll address that in
Yep.
a minute. Mr. Brooks, do you have any cross-examination for this witness?
No, Your Honor.
All right. Sir, you can just stay right there. I don't think there's any members of the public. Are there any members of the public that would like to comment on case number 627, DAG Brothers, with property location at 194 Boardwalk Place? Okay, seeing none, is there anything else the city would like to present to me today?
I just want to clarify, the original courtesy notice was sent out December 13th of 2018. I understand that you guys just received it 10 days ago, but it has been on my side open, so to speak, for almost 4 months, so that's why it's the original notice, which was sent out on the 13th. And then the only other thing I wanted to add is, even if they were relocated, we don't know if they were permitted there in the first place, because we don't know if they're allowed to exist as they are now. That's all.
And I think if I understand the nature of the violation, Pinkerton, correct me if I'm wrong, that the violation of 86-52 is that they altered a structure, meaning they altered the dock by moving the awning from one point and putting it in another without a building permit. Is that correct?
Correct.
All right.
If I could, Your Honor?
Go ahead.
Holden, what is the apparent purpose of the awning? Is it to keep customers in the shade as they wait?
It looks that way, yes.
Is there other possibilities they could use, perhaps removable umbrellas or something like that? Or?
Something temporary, yeah, something that could come up and down. Something you could take down at the end of the day and put up first thing in the morning.
Okay.
All right, anything else from the city?
No, Your Honor.
Anything else you'd like to tell me, sir?
No, I just think that unfortunately, when I reached somebody after I spoke to you, there's no way I'm going to drive back down there in that traffic jam that's going on. So I would have run back down and checked it again and been a little more assured of what what Holden had told me, but so I'd understand it better to discuss it today. But I mean, I think that nobody's got any ill intentions on this. It's just that the people leasing the site had the work done. D'Agostino Brothers were totally unaware of what the status of it was, weren't aware that the awnings got removed. They didn't even know there were awnings there when I called them, when I finally did reach one of them. And so I would appreciate if we can.
No, I understand, sir. And here's what I'm going to find. I'm going to find that the property is in violation based upon the record before me today. But, sir, here's the corrective action, and this is what the city has requested, so I'm going to go along with it. The city's requested, and the notice says that the property owner and/or licensed contractor will need to apply for an after-the-fact building permit. So I'm going to give you 30 days to apply for that permit. If you apply for that permit, then that will resolve this particular violation. However, if that permit is denied for some reason, there could be a subsequent proceeding. So the corrective action you've got to take is merely applying for the permit. If the permit's granted, denied, whatever, that may result in a subsequent code enforcement proceeding.
Sure.
But you'll be able to remedy the violation in this code enforcement proceeding by complying with what the city's told you to do, and that's applying for a permit, because that's what the notice was. I think that deals with the notice issues and any objections you have to the notice issue. It gives you time to comply. If you do not apply, if the landowner does not apply for a permit within 30 days, then I do agree with the city that a fine of $250 a day for that one violation is appropriate. So it'll be 30 days from the date I sign my order that you'll have to submit for a building permit.
Yeah,
Tim?
I probably will get it in by the end of the week, because now that we're aware of it, this can get right in. We'll
Perfect.
try
And
to-
then in that case, just make sure you follow up with Mr. Pinker, because you'll need to make sure that an affidavit of compliance is
I
filed,
will.
so there's no
Okay.
issues on the property moving.
Yep, that's fine. Thank you.
Anything else from the city? Any other matters on the agenda today?
No, sir.
No.
All right, with that, that concludes the code enforcement hearing today, and that is all the matters before the magistrate, so that will conclude today's hearing.
Thank you, Your Honor.